We're gonna go ahead and get started again. Thanks so much.
Welcome to the next session of our panel, which will focus on regulation and policy. Our panelists are Christina Lee, Simon Coghlan, and Christine Parker. Christina Lee is a visiting associate professor of law and a privacy and technology law fellow at GW Law. Her research explores how the law should address the harms of emerging technologies, particularly AI. She examines how the complexity of the tech ecosystem challenges efforts to use traditional legal frameworks that predate the rise of AI to address the harms of AI. Simon Coghlan is a senior lecturer in digital ethics in the School of Computing and Information Systems and the deputy director of the Center for AI and Digital Ethics at the University of Melbourne. He is also a moral philosopher and a veterinarian. His research includes projects on companion and care robots for groups including older individuals, animal-computer interaction, the anthropomorphizing of machines, and digital technologies in healthcare and public health. Christine Parker is a professor of law at Melbourne Law School at the University of Melbourne and the chief investigator in the Australian Research Council Centre of Excellence for Automated Decision-Making and Society. Her teaching and research has focused on lawyers' ethics, business regulation, animal law, food law and policy, and the digital economy. You can find more information about the panelists on this event's webpage. For this session, each panelist will have 20 minutes to speak, followed by a Q&A session. The session will be recorded and posted on the GW Animal Law YouTube page. In this session, we will hear about a range of topics, including AI law with a focus on the US, automated decision-making, AI animal impact assessments, how regulation might protect animals from harms related to AI, and animal privacy. So we'd like to begin with Professor Christina Lee.
Is this working now? Great. Hello, we'll get started. First of all, thank you so much for the organizers of this very cool conference for having me be a part of it. I'm very excited to learn with all of you. And so what I want to do for the next 20 minutes or so is give you a very, very high level overview, especially given the time constraints, it's going to have to be very high level, of how our legal system currently thinks about regulating AI more generally. And I'll mostly focus on the US, but with these things, I will have to talk about the EU for quite a bit as well. A few disclaimers. So AI is an ill-defined term in the law in the sense that like all of these laws that talk about AI define them differently. So a lot of what I'm going to have to talk about is going to have to be broad brush strokes because not every law is talking about the same thing. And also, this is an area of law that's constantly evolving. So what I talk about today will probably be outdated fairly soon. And so the short version of my talk is first, there are a lot of laws that predate the rise of AI that are actually very relevant to our conversation today. But we are still seeing a number of AI-specific regulations being introduced and enacted across the country and the world. And the risk management approach seems to be like the really predominant approach that's emerging now. And third, things are shifting rapidly. So first, we'll talk about how the laws of yesterday remain very relevant to our conversations about emerging technologies today. And then we'll take a look at new legal frameworks that are emerging. First, looking at discussing how the European Union has approached this issue, and then coming back to the US. So the first thing I want to highlight is that we already have a lot of legal frameworks that have been with us for a long time that don't have the words artificial intelligence in the legal text, but they're very, very relevant to our conversation today. So Joan earlier mentioned how animal law intersects with a number of all areas of law. And you can say the same thing about AI, right? Because AI didn't rise in a legal vacuum. And the reason that AI is becoming an increasingly important topic in our conversation is it's used in situations that have long been considered legally worthy of attention. And so many common law and statutory frameworks that predate the rise of AI remain very important to this discussion, be it torts, environmental law, anti-discrimination law, information privacy, or copyright. So for instance, I'm sure a lot of you have heard that a lot of companies are using AI to screen resumes for hiring purposes, right? Well, Title VII of the US Code prohibits discrimination along protected characteristics like race and sex and employment. And that doesn't just go away just because there's AI in the mix now, right? So Title VII is relevant in how AI is being used. And indeed, there's a lawsuit that's currently going on, Mobley v. Workday. And the core claim in this lawsuit that survived motion to dismiss is that Workday's AI product for resume screening that's now being used by hundreds of companies has a disparate impact against people in the plaintiff's demographic in violation of Title VII. So Title VII is directly implicated in this AI-centric lawsuit. And I'm sure you've all heard about lawsuits claiming copyright infringement against generative AI companies, like the New York Times v. OpenAI case. And here, Copyright Act, which also far predates AI, is now directly implicated. These laws far predate the rise of AI, and lawmakers certainly didn't have AI, at least the current version of AI, in mind when they wrote these laws. But because AI is now being used in parts of our lives that these laws care about, they are now increasingly being called upon to regulate AI. Okay, so we have all these traditional legal frameworks that have something to say about how AI should and shouldn't be used in our society. But I probably don't need to tell you that these existing legal tools by themselves don't always do the job perfectly. New technologies often bring about challenges that laws designed with technologies of yesterday just didn't have in mind, and AI is no exception. For instance, harms from AI systems have certain characteristics of distinct attributes that make them a tricky target for traditional legal frameworks because the harms don't necessarily present themselves in a way that's easily cognizable under our legal frameworks. And in addition, even when there are tangible, cognizable harms involved, existing legal frameworks make certain assumptions about the state of affairs that don't necessarily apply to this technology. So for instance, a lot of legal frameworks care about mental state of the actor in attributing liability or fault. But machines, at least as they stand today, don't have that kind of mental state. So how do those work? And also, AI-powered tools like chatbots work differently from other tools that we're more used to. So how do we? These tools that we have built our legal frameworks around, these legal frameworks don't work as well. So, for instance, some advocates have and litigants have turned to products liability for cases involving harms from AI companions. But products liability was designed with tangible mass-produced products in mind, like Coca-Cola bottles that explode. AI doesn't have that. AI doesn't quite have that. AI companions don't have that, right? So can we apply that to chatbots? Are chatbots even products that fall under products liability? So even as these legal frameworks remain very, very relevant in our discussion around AI regulation, we often find ourselves wanting new tools, new legal frameworks to deal with these issues that arise from these new technologies. So in the last few years, we've seen regulators at various levels trying to figure that out, put rules around AI specifically. A very, very popular approach that's been emerging is approaching this problem as one of risk assessment and mitigation. So one of the most significant examples of this is the European Union's AI Act, which passed last year and is slowly rolling into effect over the next several years. And it's the first of its kind, right? It's a comprehensive AI regulation at national, supranational level. And so it's kind of become a model for subsequent legislation and regulation around the world. And of course, with AI being so transnational, even without the legal framework being exported, what happens in Europe matters for the US, the rest of the world as well. And so the stated goal of AI Act is to promote the uptake of AI throughout Europe by mitigating risks from the use of AI systems. So it's important to remember that it's not an instrument that's just meant to provide protection. So at its core, the EU AI Act approaches AI from a risk management perspective. So it categorizes AI into 4 different categories of risk, right? Unacceptable risk, high risk, limited risk, and minimal risk, based on what the AI system actually does. And puts different ex-ante guardrails, requirements that have to be met before the systems can enter the market based on the risk category. So it's really about risk mitigation, not complete harm prevention. So the unacceptable risk category, so the example, one of the examples being like AI systems that create or expand facial recognition databases through untargeted scraping of facial images from the internet or CCTV footage. These are just banned, right? But and then on the other side of the spectrum, limited or minimal risk categories like customer support chatbots or email spam filters, they come with some transparency requirement. So most of the action is really in the high risk category, which encompasses a number of different use cases like use of AI in critical infrastructure, biometrics, employment related AI systems, and so forth. And so the AI Act has this conception of providers. So these are people who develop these AI systems, and then deployers. So these are the people who take those systems that's been developed and use them for their own purposes. And puts requirements on providers and deployers of AI systems. And it borrows heavily from the EU's product safety regulation framework in terms of how compliance and enforcement is structured. So before a high-risk AI system is made available in the European market, providers have to take steps to identify and mitigate risks from these systems, like creation of risk management systems, data governance systems, human oversight, and checks on accuracy, robustness, and security. And also have to perform conformity assessment according to standards to be set by standards setting organizations. So this is very much heavily drawn from product safety regulation in the EU. And deployers also have some obligations there as well, like having to adhere to the provider's instructions, especially when it comes to human oversight and also certain notification requirements. And authorities in the member nations are in turn empowered to conduct investigations and order corrective and punitive measures that can go up to 7% of a company's global revenue. There's another chunk of the EU AI Act that deals with general purpose AI models, and these are defined as AI models that display significant generality and is capable of competently performing a wide range of distinct tasks, regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream app systems or applications. So think GPT model underlying ChatGPT. So that part of the AI Act also takes a risk classification approach of dividing general purpose AI into those with systemic risks and those without, and imposes different requirements on the providers on whether the model is considered to pose systemic risk or not. But it's a little different from the earlier chunk of AI Act that I discussed, because it does this part of it, because of the some quirks in the drafting history, was drafted kind of as an add-on to the meat of the AI Act. So it doesn't really take the product safety regulation framework. And also, instead of empowering the national governments, member nation governments for enforcement, there's an EU-wide body that's tasked with enforcing this part of the AI Act, showing that the Act considers general purpose AI to be fundamentally transnational. And then there are a few ad hoc provisions within the AI Act that don't necessarily fall within the two chunks I mentioned, like the requirement for fundamental rights impact assessment for deployers, regulatory sandboxes, and so forth. So the EU AI Act is this massive legislation that has a lot of moving parts, and because it's one of the first, it's the first omnibus AI regulation worldwide, it will have a huge influence worldwide, and it has already influenced the way that regulators in other jurisdictions think about this issue. Even though large chunks of the AI Act, to be clear, isn't even in effect yet, it's already had this influence. Okay, so that's the EU. So what about here in the US? So until fairly recently, the federal government, especially the executive branch, was quite involved with AI policy making, often also leaning into this risk-based approach, though perhaps striking a little bit of a different balance from the EU. So in 2020, the first Trump White House announced the executive order promoting the use of trustworthy artificial intelligence in federal government, which required government AI to be transparent, accountable, and understandable, among other things. The Biden administration continued on, announcing the Blueprint on AI Bill of Rights, and then the 2023 executive order on safe, secure, and trustworthy development and use of artificial intelligence, which really signaled this like whole of government effort on AI governance, addressing a range of issues from future existential risks from advanced AI models to immediate concerns surrounding current technologies' ability to disseminate misinformation, enable discrimination, undermine national security, and so forth. And so that's the executive branch. On the legislative side, the Algorithmic Accountability Act, which sought to require companies to conduct impact assessment on AI systems. So that's also risk mitigation flavor there. And also, as well as empower the Federal Trade Commission to create regulations around such impact assessments. That's been introduced multiple times over different Congresses. And so some commentators looked at all of these developments and said, oh, like the US federal government is really interested in like pushing forward AI governance and AI policy. So that was 2024. Things look quite different today. So currently, the mood in the federal government is pretty deregulatory. So for instance, one of the first executive orders signed by President Trump and when this term started, rescinded the 2023 EO, which I mentioned as like this whole of government effort to govern AI. And in a subsequent EO that followed a couple of days later, the White House ordered executive branch to rescind any policies that were put in place pursuant to the 2023 EO that, quote, act as a barrier to American AI innovation. And then during the negotiations for the One Big Beautiful Bill Act that passed over the summer, there was a moratorium on state regulation of AI that was floated. It was eventually voted down, but that was definitely part of the conversation. We're going to ban states from regulating AI. And then subsequently, there was this policy document from the White House that titled "Winning the Race: America's AI Action Plan." And this document clearly indicated that the federal government is not interested in regulating AI, stating, quote, AI is far too important to smother in bureaucracy at this early stage, whether at the state or federal level. So that's not to say the government has not been doing anything in regard to AI at the federal level. So for instance, the government has been very active in export control for chips, which is of course an essential element for state-of-the-art AI right now. But it's pretty safe to say that federal government is not really keen on regulating AI currently, especially as it relates to like the everyday harms, societal harms that come from AI. But fortunately, that's not the end of what I'm going to talk about, because as I mentioned, the effort to put a moratorium on state-level AI regulation didn't succeed. And several states have been very, very active in this arena with varying scopes, some taking cues from the EU AI Act. As I mentioned, AI Act has been this blueprint for a lot of different governments to look at and follow. And also others are a little more specific for specific use cases. So the big one is, of course, in Colorado AI Act, which passed in 2024. It became the first, so Colorado is the first state in the US to pass a comprehensive AI law. And it shows very clear EU AI Act influence. So like the EU AI Act, the Colorado AI Act also takes a risk-based approach to AI and puts different requirements on developers. So these are providers in the EU parlance and deployers of AI systems. So for AI systems are considered high risk. But I have to say that this is a little narrower in scope than the EU AI Act in terms of what the law considers high risk, as well as the focus of the harm, right? So the Colorado AI Act is really focused on discrimination harm. Texas earlier this year passed the Texas Responsible AI Governance Act, so Texas was like, depending on how you count it, it's second or the third US state to really have a comprehensive AI law. So Texas AI Act also a little narrower than Colorado AI Act. This one focuses on targeted prohibition of certain use cases of AI, such as using AI to manipulate human behavior. We also see emerging state level laws focus on specific application of AI that people are especially concerned about. I'm sure a lot of you have seen news articles about AI psychosis. So Illinois has this ban on AI therapy now. And I'm sure also a lot of you have seen articles about AI companions and how it's been harmful to children. California has a law restricting AI companions for children and other vulnerable population. And then also California has another law that's more focused on catastrophic risks, like California's recently enacted SB 53, which requires large AI developers to disclose safety information, report critical safety incidents, and protect whistleblowers. There's a lot of state laws that are being introduced and banded about around AI, and there's just absolutely no way I can cover all of it in this short time, but hopefully this gives you some idea of what's been going on. I do have to acknowledge that even though the states seem quite active in regulating AI and trying out different models of AI regulation, the headwinds to those who want to regulate AI, especially in the US, are quite strong right now, and things are shifting as we speak. So I mentioned that Colorado became the first state in the US to pass a comprehensive AI law. So that law was supposed to go into effect February of 2026, but after some back and forth, the enactment date got pushed back by several months to end of June. In the form of Texas AI law that was passed, I mentioned that it's quite a bit narrower in scope even than Colorado AI Act. The initial introduced version was actually quite similar to the Colorado AI Act, but the actually enacted version, the version that was signed into law, is quite a bit narrower. The SB 53, the Frontier AI regulation, it's actually a much weaker version of this a predecessor bill from last year. So last year there was a bill on Frontier AI regulation that passed legislature but got vetoed down, and the version that passed and was signed into law this year is a narrower version of that. And of course, even though the moratorium itself didn't pass, the AI action plan that I just mentioned earlier clearly shows quite a bit of hostility towards AI, state AI law. And this is not just a US only phenomenon. Some other jurisdictions that have been a lot more active around AI regulations are also seeing calls for delays in scaling back. So to conclude, the state of AI regulation right now is kind of hard to define. There are long-standing laws that regulate AI in important ways, even though they were never meant to be used for AI regulation. But because they're laws of yesterday, they're often not enough in effectively addressing AI harms. So we have all these new regimes coming up in the US, mostly at the state level, as the federal government is kind of dialing back on regulation of AI. Some of the laws are influenced heavily by the EU's pioneering AI Act and embracing the risk-based approach. Though a little bit narrower in scope in the US generally, and others are more targeting specific uses of AI. It's a complicated mess, but it's an important mess to keep an eye on, in my opinion, as AI is posed to become ever more pervasive in our lives for good and for bad. And with that, thank you so much.
Okay, great. Thanks for inviting us. We're thrilled to be here from the Southern Hemisphere and the Eastern Hemisphere. And Simon and I are going to share this talk, which is about integrating animal law and ethics with AI law and ethics. So Simon's going to focus on why attend to non-human animals in AI law and ethics and what ethical principles could or should apply. And then I'm going to focus on how to integrate these animal ethics into AI law, building on three broad ideas from animal law scholarship, which I'm calling recognition, responsibility, and representation. But first, I thought it might be helpful just to clarify what we mean by AI in this presentation, although we've just had a brilliant exposition of it. So just to be clear about what we mean, we're seeing AI as an umbrella term for a range of techniques that enable software to approximate autonomous and adaptive human thinking and behaviours. And it has various modalities like classification, recommendation, prediction, translation, decision-making, and of course, text and image generation. So we're not looking at AI as the one sort of artificial super intelligence that Sankalpa mentioned for the future, but as multifarious general or foundational models and contextual tools and applications. And it's really urgent to talk about AI now, because although many of these software techniques have been around for a while, they have significantly sped up and scaled out in the last few years. And that's partly technical, as Sankalpa explained, to do with big data, chips, and developments in machine learning and in neural networks and so on. But it's not just a technical development. It's a social, cultural, economic and political development. And AI technologies and the associated datafication and automation are being rapidly integrated into every area of government, business and life, and they have the capacity to substantially change human-animal relations and the management by humans of non-human animals. And farms and conservation and so on. And this is a significant development, perhaps akin to the development of industrialised animal farming and slaughter that really deserves our urgent moral attention. So I also should say we're not going to focus on the material infrastructure of AI, which does have a significant environmental impact and therefore impacts on animals' habitat. That's important, but we'll be focusing on the models and the tools that affect animals either intentionally or unintentionally, directly or indirectly. And I'm going to turn to Simon now to talk about that more.
Thank you, Christine. Hi, everybody. Good morning, and really thrilled to be here as well. I'm going to talk about three things. The first thing I'll talk about is a framework we have for harms and benefits for animals from the use of AI. And I'll then talk a little bit about animal well-being and how that fits in. And then I'll finish up by talking about some AI ethics principles and how they might apply to animals. So I'll start with this framework for harms and benefits. Because AI has very many applications, it can be useful to try and classify and capture some of the possible harms and as well as benefits that could flow from the use of AI for animals. So in developing this framework, we turn to the animal welfare scientist, David Fraser, who had his own framework for classifying animal harms. And the motivation he had for developing that framework was that he was concerned that a lot of harmful practices that human beings engage in, harmful to animals, simply go unnoticed or unaddressed by either animal welfare scientists or ethicists. And he was concerned about that. Things like the fact that windows are designed in such a way that often facilitates bird strikes, and that kills millions of birds. And he was concerned about that. He was also concerned about the fact that while some of the harms that we cause to animals are fairly direct, other ones are much more indirect and therefore may escape our attention. And he also wanted to point out that the way, the kind of nature of the practices and activities we engage in can affect how we impact on animals and can also affect how we should go about addressing those impacts. For example, the fact that we keep companion animals gives us certain ways to address their well-being, which is different from the wild animal case. So Christine and I, in a paper, developed this framework for animal harms that result from AI. This particular framework here is in a paper that's mentioned down the bottom there, and is also in the MIT AI risk repository as well. I won't go through all these in great depth. I just want to point out that that there are a range of ways or pathways in which harm may occur to animals. This could be intentional or unintentional harms. They could be direct or indirect, and they could be legal or illegal kinds of harms. We also do want to say that, of course, AI has the potential to create great benefit for animals, with the potential to do so. And one of the ways it might do that is by reducing our existing harmful practices towards animals by providing alternatives. So I'll just give you some examples of these kind of categories. So Fraser doesn't talk about so much about illegal and legal categories, but we want to mention that the fact that some uses of AI on animals or regarding animals might simply be illegal. And for example, using AI to torment or say provide electric shocks to animals in farming. might be illegal. Other kinds of activities could well be legal. That is, activities which cause great harm to animals, such as in intensive farming situations. And the way we address those might be different. So with illegal harms, for example, surely is a minimum that we enforce the laws, as was mentioned this morning, I think, that those laws are properly enforced if they exist to protect animals. And that might in itself not be quite enough, because we might need to have other ways of monitoring when these illegal harms are being perpetrated. AI might be involved in that particular process too. When the harms are legal, then it raises the question as to how we are going to address those particular harms if they are within the bounds of the legal system. Fraser, in his framework, pointed out that some of our harms are intentional. We intend to harm animals, and other harms are unintentional. So if we turn to AI and give some examples there, we could cause intentional harm to animals, for example, in conservation, where people deliberately set out to kill animals designated invasive. So here's an example from Australia. It's called the Felixer system, which is a smart trap that identifies animals such as cats and delivers a lethal dose to them of poison, and is supposed to discriminate between cats and other, say, native Australian animals. AI can also be used to benefit animals, so there's a lot happening with veterinary care at the moment, AI and veterinary care for benefiting animals and their well-being. And then there are also unintentional harms, which Fraser reminds us not to forget about. So this was also mentioned this morning, self-driving transport that doesn't identify cats properly, in the Waymo example. An Australian example was a Volvo system, which failed to could recognize moose. It's developed in Sweden, but couldn't recognize kangaroos because of their hopping. Yeah. And so they had to, that was recognized, fortunately, and they addressed it. Unintentional harms could sometimes also be a result of trying to help animals. So AI systems that, and this was again mentioned, I think Jeff mentioned it, about communication with animals using AI systems could inadvertently, unintentionally disrupt their patterns of behavior to their detriment. David Fraser also pointed to this contrast between direct and indirect harms. So some harms are quite immediate. For example, using AI to intensify farming operations could harm animals in serious ways. Whereas using AI to monitor the health of wildlife, wild animals might sometimes benefit them. But there are also indirect harms. So, for example, large language models that present animals to us in certain ways could shape our moral views towards them, especially over time. Now, that might be much harder to predict, the outcomes of those kinds of large language models. But at the same time, they could be very important and influential. Now, I've been talking a bit about animal harms and benefits, but that's a little philosophically imprecise. So I wanted to make this distinction between what is of intrinsic value to an animal and what is of instrumental value to an animal's well-being. So what is of intrinsic value to an animal is what is a constituent or a part of their well-being, whereas what is instrumentally valuable is what promotes intrinsic value for animals. And the issue here is that conceptions of intrinsic value differ between people. They vary and are the source of controversy and disagreement. So, and this is important because when we come to protecting animals, our conceptions of an animal's well-being, what is intrinsically valuable to the animal and what is instrumentally valuable to the animal, can be different. So if someone has a conception of animal well-being that involves growing well and reproducing, then that's one kind of conception, but it's maybe not a conception of well-being that would be satisfied with. Similarly, a conception of well-being might involve reducing harm or suffering in animals. But that, as a conception of the intrinsic value of well-being, is also disputed. And that dispute comes from different sources. So one of the sources of dispute is from animal welfare science. A fairly common paradigm of animal well-being in animal welfare science is the 5 domains approach, which was developed by David Mallow. Mallow said that these following things are important for an animal's well-being: that it has good nutrition, the right kind of physical environment, good health, and behavioral opportunities. And these things, and this is the 5 domains approach, lays a special stress on the 5th component, which is the mental state of the animal. If you like, you can think of the first 4 as instrumentally valuable and the 5th as intrinsically valuable to the animal. But importantly, on this approach, the mental states include not only suffering or negative mental states, but positive ones as well. And in this sense, this approach resembles to some degree this philosophical idea of what well-being is, called hedonism, or some people might call it sentientism, where well-being is explained as positive mental states, pleasure, and the absence of mental states, pain. On this particular conception, other things such as an animal's activities, its relationships, its capacity for agency have no intrinsic value. And so some people think that this is then too thin a conception of animal well-being and that we should look for other explanations of what animal well-being is. One such example is the so-called capabilities approach, which was developed by Martha Nussbaum. And the capabilities approach says that well-being consists in flourishing, and that flourishing can be explained by the possession of the capabilities, which she talks about in terms of things like life, health, and having bodily integrity, having the ability to use our senses, or in the case of an animal, its senses, or his or her or they senses, their emotions, the ability to play, including with other species, to form relationships, and also to exercise practical intelligence and control over their environment, which we might think of as a kind of agency. So Nussbaum's approach is essentially a theory of justice for humans and animals, but we could also just think of this as a conception of intrinsic value, what is of importance in animal well-being. Someone who doesn't think those things are a part of an animal's intrinsically valuable conditions for well-being might nonetheless agree that they are instrumentally valuable to the production of well-being for that individual. And so therefore, we might think that an AI system that undermined an animal's agency, maybe think of a farming situation, and that killed an animal while the animal was still young, would be bad for that animal's well-being. Some scholars are now talking about this other, and I want to mention this one as well, this idea of privacy for animals. We recognize that privacy is important in human well-being. Does it have any place or role to play in animal well-being? This kind of idea has become particularly acute because of the capacity of digital technologies like AI, the Internet of Things, to monitor animals, even in the wild, and identify them, and therefore allow people to come and observe them. So members of the public, for example, might be alerted to the presence of a rare and admired species. Now, some people think the concept of privacy simply has no application to animals. And they might point to things like animals not having a sense of shame, unlike human beings. They therefore think it's the wrong concept to apply. Others, though, argue that that the concept does apply, and because, for example, animals are interested, or at least some of them, in seeking seclusion or being in solitude at certain times of their lives. Therefore, privacy has either intrinsic value to the animal or at least instrumental value to the animal's well-being. The final thing I wanted to talk about was AI ethics principles. You may be aware that there are a number of ethics principles from the domain of AI ethics. If we accept that animals have a well-being and that well-being deserves protection, we might then seek to discover whether or not any principles from AI ethics do apply to those animals and might be useful in that situation, and whether or not those principles might help us to fashion the right kind of laws for animals. So Luciano Floridi and his colleagues identified what they thought are 5 key AI ethics principles for humans. And they talk about non-maleficence, beneficence, respect for autonomy, justice, and explicability. And they draw on these principles from the field of biomedical ethics and the famous, commonly known for biomedical ethics principles. And those principles were developed in order to guide the behavior of people doing biomedical science, medicine, and to foster ethical behavior in that domain. So these biomedical ethics principles and the AI ethics principles which are based on them have a number of characteristics. So one is that they're prima facie principles. They're non-absolute principles that can sometimes come into conflict with one another. They're supposed to be moral theory neutral. So that is, you can accept them, whichever moral theory you happen to ascribe to. And so sometimes these principles are called mid-level principles because they are not ultimate principles. They're supposed to be widely applicable, and they are supposed also to be commonly accepted amongst those who employ them. And while they might guide individual behavior, they can also guide the behavior of companies, professions, organizations who might adapt those principles for their own purposes of regulation. So now the question is, what I finish with is the question whether we can adapt these principles from Floridi and apply them to animals. So we'll just run through the principles. So the first one is non-maleficence. And this principle says that we should avoid causing non-trivial harms to animals. We should at least consider harms to animals that are non-trivial, such as suffering and death. And then we should seek to either minimize those harms or to completely avoid those harms. And of course, here our conception of well-being might come into play too, as to what kind of harms we need to be avoiding. And we might also need to consider a range of possible harms, including indirect harms and unintentional harms that we might often forget about. The second principle of beneficence says that we should promote animal well-being. So we might use bespoke AI tools, for example, to increase an animal's well-being, or we might use those tools to replace existing harmful practices which are done to animals. So those principles seem to apply to some degree. There's a principle also of respect for autonomy. And if we value animal agency, for example, the ability of an animal to make choices, to exercise their practical intelligence, and to have control over their environment, we might see that as being an important principle as well. What about the principle of justice? Well, it might be a little bit more controversial. Nussbaum had a theory of justice, so that wouldn't necessarily do as a mid-level principle. But we could think of justice or fairness as being applicable to animals and the use of AI. For example, if an animal is harmed by AI, we might see that it deserves some kind of compensation for that harm. We might also see that animals should not be treated in a discriminatory way. For example, valuing the well-being of a dog above the well-being of a pig. Floridi's principle of explicability essentially has 2 components. One is accountability. So this principle says that we need to have human oversight of certain AI systems and that we should have certain regulatory or legal mechanisms to protect animals from the AI. And the second part of that is explainability. So we should be able to identify when an AI system has an inaccuracy or a harmful bias, to identify that so that it doesn't cause harm to animals. So those principles might have some application. Here's a more controversial one. Could we have a principle of respect for animal dignity? Like the concept of privacy, the concept of dignity is now being talked about a little bit more with respect to animals, as you see from this book here. And the concept of dignity might have at least some traction. For example, it's present in the Swiss Animal Welfare Act. What could it mean? So one possible explanation or understanding of a respect for animal dignity is that we should be avoiding disrespectful or degrading or humiliating ways of talking about or treating animals. For example, a large language model that presented to us animals as being disgusting or as being fun to kill could be an infringement, arguably, of that particular principle. So finally, are these principles useful? Could they guide soft law or hard law? One issue there is what weight these principles have if we are to accept them. For example, when might it be, if ever, permissible to harm an animal in a non-trivial way? What kind of weight does animal well-being have compared to human well-being? That could be an important question to ask and answer when we're trying to interpret such principles. Also, if we're to use those principles, we might think there has to be at least some degree of agreement on the principles, and that that a certain constituency takes those principles seriously enough to enact them, just like they do in the case of the 4 biomedical ethical principles. And given that animals are, on the whole, not taken seriously by society, perhaps it will be the case that we need to accept some weaker form of these principles than we might consider ideal. And I might pass now back to Christine to finish off.
Great. So let's turn to the actually. Is that your glasses as well?
Yeah, it is.
He's just like marking his place. So let's turn to the law. So as I think Christina just explained, AI law is very much an emerging area of law, meaning that hard law, meaning enforceable or formally binding law, is lacking. But there is a multitude of soft law with varying levels of authority and for various purposes proliferating, and it's likely to shape emerging best practice and any future binding standards. And we also need to think about the fact that AI law can be vertical or horizontal. So as Christina also explained, there are some laws that seek to address AI systems as a whole, often particularly focused on general purpose AIs or particularly risky AIs. But there's also many ways in which the regulation of AI is or should be integrated into substantive domain-specific laws such as safety and design of medical products, car safety, traffic safety rules, and existing animal welfare laws to the extent that they exist in different jurisdictions. Of course, to date, AI law largely ignores non-human animals, but I'm going to suggest 3 ways to include animals in AI law, each inspired by existing ideas in animal law or in the sort of reform aspirations of animal law scholars. So I'm calling them, I'm talking about recognizing that animals are vulnerable to and impacted by AI systems. Secondly, ensuring responsibility and accountability of those developing and deploying AI systems to take ethical care for animals, and ultimately the right for animals to have representation and indeed participation in the institutions that govern AI. So I'll talk about each of those briefly. So the first one is recognition of potential harms and benefits to animal well-being in AI law. And as Simon has said, our harms and benefits framework is one way of talking about the range of AI contexts in which this is needed. And if we think from the animal law end, so more than 30 countries formally recognise animal sentience, and many implicitly recognise the value of animals as more than property through at least minimal animal welfare regulation. But animals are largely ignored in AI law. The environment is sometimes mentioned, but animals only get a glancing reference. There's a couple of notable examples. So the UNESCO recommendation on the ethics of artificial intelligence, which 193 countries signed up to in 2021, has environment and ecosystems, has one of its 4 core values, and mentions AI's impact on animal welfare and the need to protect ecosystems for all living beings. So they're in there just. And the EU high-level expert group's ethical guidelines for trustworthy AI from 2019, so pre-EU AI Act, also recommended considering the potential impact or safety risk to the environment or to animals. So, I mean, basically that's about it. So we've got a paper that we hope will be coming out before too long, where we argue that the situation is so dire that it's an improvement to even have a sort of symbolic recognition of animals in guidelines and general statements. But more than that, I want to argue that even that base level of recognition, like we see in sentience recognitions and is in some of these, is useful because it can be used as a scaffolding for developments in AI risk assessment that are becoming the main modality. And so my example for that is the EU AI Act. So we had the high-level expert group, which did mention animals. And then with the EU AI Act, when they were making it, it was environment wasn't even in there, and there was a huge fight by Greens and so on to get environment in there, but animals got missed out completely. However, when it came to the risk assessment, the different procedures for the different risk levels of AI, and Christina's already explained this beautifully. One of the areas for the large general purpose AIs, they need to establish risk management systems under the EU approach. The way the EU always does it is they have this principle in the legislation, and then they'll come up with codes and stuff. So they've recently come up with their multi-stakeholder code of practice for what Gen AI should look at for their risk assessment. And non-human welfare got included in there through the multi-stakeholder process. So that's in there as of this year. It's soft law, it's not binding, but it has a certain authority as an official statement and as the result of a multi-stakeholder process, and it could provide evidence of compliance or non-compliance with the legal requirement. And it also demonstrates how animal advocates can lean into existing symbolic recognition. So they use that sentience is in the EU treaty, the mention of animal welfare in the earlier ethical guidelines, and the work that has been done by colleagues in the room and others on risk to animals, and the fact that people who cared about animals participated in the multi-stakeholder process. Okay, so the second one is responsibility, where the substantive principles that Simon was discussing would be developed and contextually applied as standards of care for AI in relation to animals. And in many jurisdictions, we do have animal welfare regulation that does set out standards of care and who has a duty in what circumstances. Woefully inadequate, badly enforced, but we do recognise that we need to have these enforceable standards of care. And as Joan also said, it's expanding in some jurisdiction into other areas of law, such as family law, domestic violence, protective orders, conservation, animal welfare does need to be considered in various conservation practices and so on. So why not expand these standards into AI law and take on board these ideas of animal well-being and principles of non-harm, beneficence, even privacy or dignity, that would be relevant for many sector-specific AI standards, such as automated vehicles, medical/veterinary devices, the new technologies that are being developed in animal welfare, that claim to promote animal welfare and animal agriculture and so on, because there will be standard, even if we don't have hard law standards, there's going to be technical and engineering standards and so on, which will incorporate some consideration of ethics. And so these are opportunities for animal standards of care for animals to be included. One important question here would be whether there are some uses of AI that should be prohibited as of completely unacceptable risk or deemed so high risk that they should be subject to very stringent regulatory requirements, such as independent safety assessments and so on. So, for example, in the EU, biometric surveillance for humans is banned as a basic dignity rights issue. Should biometric surveillance of animals that leads on to autonomous decision making in factory farming, or CAFOs as you call them, also be banned? Or if it is allowed, should it only be allowed if there's a human in the loop and strict safety testing and requirements around it? What about AI for benefit of animals? So AI that might speak for animals as clients in court or governance processes. While this might be highly beneficial in its promise, the cost of failure, if it was corrupted or if it got it wrong, is really high. So what safety standards should we have around that? So I think we can start with some of these things with voluntary guidelines and soft law. And a nice example is Project SETI, the whale song translation and communication project. They invited the NYU More Than Human Rights Project to co-design ethics and governance principles with them, which I think they're about to release. And my team and I in our centre, we're just beginning some work with Australian conservation monitoring organisations to do a similar thing and try and develop some ethics and governance around all the data sets and AI that a lot of them are using. But ultimately, of course, we need enforceable duties of care in AI law. And we need to answer questions about who will be the responsible human in the loop. How can we make the companies that are developing these things responsible? Can we make the AI systems themselves responsible in the way that we often make companies responsible or try to make them responsible? And this can be done through both vertical regulation and also through all the horizontal opportunities that there's going to be for standards development. Come back to that one. Now, the third one is representation or participation in governance, essentially. So this is about creating institutions to perpetually represent and guard animal well-being in accord with the ethical principles or standards of care in AI governance. Some of the things that I'm thinking about here are that we need, so in animal law, there are various wonderful ideas about trying to create the idea of guardians for animals, of animals having intellectual property rights. Okay, so there's a lot of data floating around. We're collecting a lot of data. How are we going to assure that that data is used for the animals? Should we have data trusts for the animals so that that data gets used for them? Can we establish and protect animals' own right to their own data and their own apps and platforms and so on? But a nice starting point of a perpetual institution that might be a bit more achievable is from the UK, where they introduced a couple of years ago, it's called the Animal Sentience Committee, which is a slightly misleading name, but they have a mandate for this mandatory animal impact assessment for all laws and policies that affect animals in the UK. So it's a bit like a human rights impact assessment or a environmental impact assessment or even a regulatory cost benefit assessment. So they can do this assessment. And so they, in a sense, represent the animal's interests across all policy domains, not just animal welfare. And just going back to that one. So a nice example of this was in the digital area is that a few years ago when the UK introduced their new Online Safety Act to put requirements on digital platforms, they basically said, okay, digital platforms, you've got all these algorithmic systems and whatever, and part of what they do is they end up promoting illegal stuff like child abuse and so on. So we're going to make a list of existing criminal offences that you digital platforms are going to have a proactive duty to make sure that your systems don't show that content or don't promote that content. And the Badger Trust said, hey, how come animal cruelty isn't on that list? Because there's a lot of cruelty against badgers and stuff being shared online and so on. And they changed it. They added animal cruelty to the list of priority offences. And the animal impact assessment was part of sort of discussing, well, how was that done? How could it have been done better? Was it a good idea or not? So I think this is a marvelous option because it shows us how we can start to integrate existing standards into regulation of AI and digital tech. So that's actually the end of what I wanted to say. So I've put a little summary slide up there so that you've got the whole story, our 3 ideas for animal law integration informed by the AI ethics, the framework and the reworking of wellbeing and the ethics principles. Thank you.
We have about 25 minutes for questions.
Okay, thank you for the presentation. So I have one opinion, then I have a question. So first on the EU AI Act's code of practice and how that non-human word came about. It didn't came out of a vacuum. So what happened with the EU AI Act code of practice is that they open up to a lot of industry and actually scholarly stakeholders for them to contribute to the code of practice. And 6 animal advocates, 2 of them are actually here, myself and Sam. Sam, are you here? Yeah, Sam Tucker. And 4 other animal advocates participated in this process of drafting. And actually, it didn't appear in the first draft. All 4 drafts are online. I think they're still online. You can see that it is not in the first draft. I think it only happened in the second draft, right, Sam? It started to appear. We actually asked for animal or non-human animal, but they choose to include non-human instead, which is better than nothing, I guess. Maybe it is better than just animals because it is more inclusive, potentially to even I don't know, non-carbon based life or sentience. But also, it has the disadvantage of not specifically mentioning animals as one of the potential stakeholders there. But anyway, yeah, it's better than the first draft. And I think if none of us participated in that process, it just wouldn't be there. So I think efforts in lobbying for these kinds of changes could it matters a lot and it could succeed, and we show that we succeeded in this case. And actually, my question is related to that. So I don't understand law and also not EU law, I guess, but there seems to be a document that people call to be the quasi-constitution of the EU, which is the Treaty on the Functioning of the EU. Article 13 says, actually, I lost that tab, sorry. Uh, yeah, I want to, maybe you should hand the question to someone else as I pull that tab back on. I don't know why it got closed. But yeah,
Okay.
can you come back to me later?
Yep, we'll pause and we'll go to Mariah. You.
Thank you for your presentations today. I'm just curious what your thoughts are on this little hypo I've come up with in my mind. My question is really like, do you think legally recognizing animals as victims, whether it's in a statutory or judicial system context, would kind of help expand protections or possibly bypass the need to explicitly include animals in laws or regulations that protect against the ill effects of AI?
Yes, I'm the most animal law person on the panel. So is that on? Yep. Yeah, I guess you're kind of asking a version of the question, would making animals legal persons improve things, or are you sort of, I mean, I think it works both ways. It's like we have to have it often comes down to the construction of each piece of legislation or each standard, who actually counts as a person who's been impacted, who can sue or who can be counted as a victim or a defendant or whatever. Yes, so absolutely. I think there are some really creative ways that advocates for animals could argue that animals are already impacted and try to seek legal redress already. So it's a bit easier, like in Australia, for example, it's a lot easier to establish standing, or it has been, and that might change, than what it is in the US, so, for example. So, yeah.
Yes, I found that article again. So Article 13 of the Treaty on the Functioning of the EU says, in formulating and implementing the Union's agriculture, fisheries, transport, internal market research, and technological development and space policies, the Union and the member states shall, since animals are sentient beings, pay full regard to the welfare requirements of animals while respecting the legislative, administrative, provisions and customs of the member states, relating in particular to religious rights, cultural traditions, and regional heritage. That's the whole Article 13. But the EU AI Act, as you pointed out, didn't mention animals, and I guess it is reasonable to claim that AI relates to or like is within the scope of technological development. So it kind of violates the treaty, and didn't respect the treaty fully. And actually, the EUA Act cited that one of the laws, or like I don't think it's a constitution, right? But one of the treaties that they have to respect, and they did respect in when it comes to human rights, is this treaty on the functioning of the EU. But when it comes to the animals, they didn't pay attention. So I guess did they make a mistake? Did they make a mistake, or like did they do unconstitutional thing? I guess this is a question for Christina and Christina.
I can say something. So firstly, thanks for telling more of the story about how that got into the code of practice. And I've had a chat with a couple of the other folk who participated, and I was aware of that, and really glad that happened. And I think I think it's really correct of you to point out that it doesn't just happen in a vacuum. It's because animal advocates take responsibility and think creatively about where to actually participate. And that was one of my points there, that there are many of these sort of standards committees and processes where there may be opportunities for animal advocates to participate. In Australia, when we make animal welfare standards, of which we make quite a few for the agriculture industry, and in a few other places, they're largely industry dominated. They're not that great. They're better than the US ones. But there is a general recognition that there's two major animal advocacy organisations in Australia, and that they have to participate on those standards committees. So this is a enduring way that there can be some sort of recognition. And I think that's what I'm not, Christina may be better on EU law than I am. I'm not a great expert on the treaty and how it works, but absolutely, yeah, they made a mistake but somebody's got to advocate for everything. And as I understand from what I saw from one of your colleagues, that provision in the treaty was very heavily leaned on for that, for the argument that animals should be included in the code of practice, and whoever was making the decision at the end of the day.
It should have been in the EAI Act.
It should have been. It absolutely.
Then you do have it, at least start with the code, and that's roughly what we said.
Yeah, exactly. Yeah. And I think, so that won the day. But I don't know whether there's any constitutional challenge available to the AI Act to rectify that, or whether that just has to be a moral argument that's made in the policy process. But that may be something that's worth looking into as a strategy. I don't know. Do you have any thoughts, Christina?
Not much more to add, except even if one could make an argument that it is against the treaty to not have included animals in the text of EU AI Act. And I would like to point out that EU AI Act, a lot of the implementation detail is going to be by standard setting body. So the AI Act itself doesn't have a ton of details, right? So there is that too. But also, it does make me wonder who would have the standing to, I don't know EU standing doctrine very well, but who would have even the standing to bring that up is something I would wonder about.
Great. Thank you all. I have a first question, which is sort of just a comparative law question. How do you think of sort of AI and children and, all of these sort of things and children as a analog or even incapacitated subjects broadly, right, for being represented into the legal system? And then a second question is, kind of like Chevron here in the US and the administrative state and regulatory capture and sort of the setting of standards. And on one side, it's okay, you won't be able to do fines, as Joan spoke to, but at the other side is maybe some of the enforcement goals that had been there might start to be adjudicated in juries or in other spaces. So yeah, two separate questions, but comparative of how does this compare to other places of beings we're trying to protect and to some degree it's advanced. And then the other is, what does regulation look like in a new paradigm?
I can take the second question probably better than the first question. So in terms of for folks who are not super familiar with how the recent developments in the U.S. law, Chevron deference, which has been a deference to administrative agencies, and when laws are written vaguely or ambiguously, then there would be a deference to administrative agencies. That's been struck down, so now the courts get to decide. I don't know that it'll be jury as much as the judge, but in the U.S., so Chevron is mostly a federal thing, right? And in the U.S., I don't know how much in the near term future federal law will have an impact on, especially when it comes to AI, which is what I focus mostly on, for all the reasons I just talked about, right? So I think in states it'll be different, and so it remains to be seen what'll happen, I think.
I think the Chevron thing is a very US question. I think in our system, you always tend to have appeal to the court for any penalty anyway. But on the other hand, we're not as adversarial about all the rulemaking and so on. But in other words, I think different countries do regulation quite differently, and I don't think you have to assume that the way it used to happen in the US is the only good way that it can happen. But yeah, capture's always a problem no matter where you are.
If I can just respond to that is, there's a Somerset decision, right, that people talk about as that was the first time habeas corpus was recognized for enslaved human beings in the UK. And so that was one judge who said, I recognize. So maybe it's just, are there victories in whatever space of the legal system that we think your approach will say, and who's going to be the one, standings committees, judges, whatever, juries?
Yeah, I mean, I think
who agrees with you and makes it law, basically.
Yeah, exactly. And I think there's a lot of creative ideas that animal law people have been coming up with. And I've got a million ideas for how you could do that. So, although I am a bit jet lagged at the moment. But I think there are many ways and places. I mean, I'll tell you, one of the ones that was really good in Australia was in not to do with AI, but in just one of the nice things that happened was when the zoos wanted to bring in more Asian elephants. Well, they had to go through a planning, they have to get approval to bring exotic animals into the country. And the judges in that case just took it upon themselves to do an absolutely deep dive into the ethics of having elephants in zoos and where are the elephants coming from and what do they need and so on. Now, they didn't stop the elephants coming to the zoo, but they put a whole lot of conditions on the approval that meant that just in the last few months, it's taken about 10 years. The elephants have been moved from the city zoo to a really large, wide-ranging zoo. So, you know, it's like, okay, wins and losses, but yeah, exactly. It was that sort of thing. It was partly because of our standing rules that it was actually, yeah, that a group was able to make that, an animal advocacy group were able to make that argument, but they were just treated so seriously, and the court did this complete deep dive, which has really changed the way that zoos in Australia treat these animals. So I can see things like that that could happen in this space as well. And you also asked about children. I'm not that great on children's law or children's right in general, but this is one of the areas where animal law has often drawn analogies with children and said, well, if you can have, you know, a guardian or who speaks for children in court, or a separate representation for children, or a trust for, you know, for children, then why can't we have the same for animals? So yeah, I think there's some of the ideas. And then of course, we're also expanding in our idea of what children are capable of, and how much autonomy children can have in the law. So we're not just sort of thinking of it in that really paternalistic way anymore. And so I think that's also very helpful for animals. Yeah.
My question is, I guess, for Christina, but anyone can answer if they have something to add. And this is really just a germ of a question. I'm not exactly sure how to formulate it, but since AI systems know no boundaries in terms of geographical areas, how can you really develop these laws when somebody can be in one country developing a system? How can these laws and regulations that are being developed actually be enforced when, you know, it's a very global phenomenon?
Right. Yeah. So I think in like tech law more generally, that's always an issue, right? So with the EU AI Act, the approach that they've taken is in order for you to market this in the EU marketplace, and you have to follow all of these things, right? And so there's like a, you can't sell to Europeans unless you have all of these. So like that's one way to make sure to try to get companies to enforce that. And then of course, a lot of these because EU is a major market, a lot of companies will have European presence, and so that's like one way to get to them, right? But like there is always an issue if a company is like wholly outside of a jurisdiction, and they don't really have much of a presence in a different jurisdiction, then yeah, it is hard to enforce, and that's always been an issue in the tech law realm for sure.
About 8 minutes. We also have a prepared question for Dr. Coghlan. So you discussed concepts of animal privacy and dignity. And the question is whether you think these ideas are too controversial or too vague to be included as an AI ethics principle.
Okay, thanks. Thanks for the question. I mean, these are certainly more controversial questions. You know, applying a concept like privacy or dignity to animals, and philosophers are discussing these issues now and disagree amongst themselves. So you know, some philosophers think that, and now you know, arguing strongly that animals do have a need for privacy. It could be, for example, that that at certain times in an animal's life they want to be away from observation. So simply not being observed is to them an interest. It could be when they're giving birth, for example, or it might just be when they want time out from others. And so if so the argument might be that if animals value that in itself, that is, they value not being under observation, then that is an interest that we ought to pay heed to. And it might differ from it's easy, I think, to accept that a lot of animals experience negative states when they are being observed by certain other individuals, either from their own species or from other species, particularly animals that are prey species. And being observed can be a source of anxiety and discomfort and even suffering if it occurs for a long period of time. So whether that gets you over the line to recognizing that animals have that the concept of privacy does apply to them is another question. So some people argue yes it does, and others will argue no, it doesn't really. It's not distinctive enough a value. We can talk about that kind of value in terms of, for example, anxiety rather than a concept of privacy. Yeah. So there's an ongoing debate there. It'll be interesting. And some people just think the whole concept is just ridiculous. We shouldn't be using it in regards to animals at all. In terms of the concept of dignity, yeah, I mean that's also going to be controversial, including amongst philosophers that are favourable towards animals. What's interesting, I think, is that there are more people starting to talk about it. And I put up a book before in which a whole series of authors have discussed whether animals have dignity or not. And one of the issues with dignity is a very complicated concept, and there are many different ways of understanding it. I guess for our purposes, in terms of protecting animals, we might want to work out what conception of dignity might allow us to protect animals best. And if it's something like the way we talk about animals as either being valuable or not valuable, the way we talk about animals in demeaning tones, the way we might refer to animals using language that seem to deprecate them. So, for example, talking about animals as an invasive species or talking about an animal as a pest. And who mentioned livestock this morning? Talking about animals as livestock rather than as individuals with their own needs, well-being and lives. Then maybe that has some traction, even with people that might be initially hesitant to say that the concept of animal dignity even makes sense. Yeah. So I think this is an ongoing space where people are thinking about and developing these ideas. It'd be interesting to see where it goes.
As you were just saying that, the privacy notion, some of the things I think we've been talking about is how AI can be used if you're monitoring wildlife and like to enforce the Lacey Act or something to actually help the animal. But if in helping the animal, we're then infringing on their privacy rights, even assuming we do, right, recognize their privacy rights, I'm wondering how do we then balance, right, if the actual use of AI is ultimately to benefit the animal, but it's infringing on its privacy rights. I mean, this comes up, I guess, in a variety of contexts in law all the time. I mean, do you see, how would we actually do that balancing, do you think?
Well, it's a really interesting question, isn't it? And we already face those kind of trade-offs with human beings.
Right.
Yeah, sometimes incursions upon people's privacy are justified, necessary, important. Sometimes privacy has been used as a screen, hasn't it, for abusive behaviour. And so privacy, might think, is not an absolute value. It's a relative kind of value or a contingent one. And the same thing might apply to animals. and sometimes if we think of factory farms, one of the problems there has been there's too much privacy.
From the outside.
Yeah, from the outside. So the public is just often not aware of what's going on. And there are laws, in fact, called ag-gag laws, aren't they, colloquially, that prevent us from seeing what's going on behind the walls. And there I think that the privacy is, there's too much seclusion. So there clearly has to be some kind of trade-offs. But it's interesting that people are thinking now that, like with all these sensors being placed in the wild, with our increasing ability to identify species that people want to view. There's a paper out at the moment about the snowy owl and how it's such a prized species that people flock when there's a report of a snowy owl. People flock to see and take photographs, and they're bird watchers that do this. And there's a real worry that these animals are going to be negatively affected by that, feel fear, fly off and get hit by vehicles and these sorts of things. So their privacy, if we think of privacy or something like privacy, you might think that those owls deserve a degree of not being observed by the general public so that they can live their own lives in safety and relative comfort.
I think this is a real issue, that we have all this promise that we can put all these devices everywhere and monitor animals, and that there's, I forget his name, but he's written this book, Internet of Animals, and it's really exciting in one way what we could know and understand, and Project SETI and so on. But on the other hand, for a start, we're putting little things, little plastics and metal and stuff everywhere, and we're burdening the animals. And I think, it's going to be contextual, obviously, but I'd be really interested in having conversations about, well, what do we already know about what we need to do to protect those animals, and is what we're going to gain from being in their space and doing this, that, and the other going to be significantly any more than what we already know and what we can politically argue for? Because, for example, if we took the idea that a third of the planet should have its habitat protected, maybe we should all just be doing that rather than putting all this effort into this other stuff. But also, can we have a lot of animals we can talk with? We don't need the AI to help us talk with them. We can that might be nice. I'm not saying it wouldn't be lovely, but there's a lot that we can already see about how they feel about how we interact with them and how we're using technology with them. So maybe just stop for a moment and pay attention to what they're telling us. There was a beautiful story in Australia. I don't know if you know about the Australian magpie. They're a very smart bird. They've been shown to know people, so like if you were horrible to them once and kind of bash them away, they'll remember you forever and attack you. They're the ones you have to worry about, they're going to attack you. But if you are nice to them once, they'll also remember you forever. Anyway, scientists were putting all these little devices on them to monitor them. And basically the mother magpie, the matriarch, figured out how to take the devices off, and as soon as the scientists were putting the monitoring devices on, they were just going, and they couldn't take it off themselves. They needed the other magpie to help them, but yeah, they took them off. And you sort of got to say, okay, well, I think they might be telling us something there. And the scientists were totally well motivated, of course. They love magpies, and I'm not saying they were doing something wrong, but let's just have a think.
To their credit, the scientists actually turned the story then, didn't they?
They
They were
did.
initially interested in
Yeah.
in tracking the birds and so on, and then it became a story, a scientific investigation of the bird intelligence and sociability and their ability to work together to overcome these kind of things which they didn't like.
Well, unfortunately, we're at time, but let's give a big thank you to our